daycare provider Mary Jenkins is suing her former clients, Cynthia and Tom Wyatt, for unpaid babysitting fees. The Wyatts are countersuing for the return of the money they paid.
Order. All rise. This is case number 488 on the calendar in the matter of Jenkins versus Wyatt. Parties have been sworn in. You may be seated. Folks, have seats, please.
Mrs. Jenkins, you are a daycare provider, is that right?
Yes, I am.
How long have you been a daycare provider?
Most of my life. My new license was granted to me on 2001.
Before that, before 2001?
I went to college and updated my early childhood development for children. Before that, I also worked as a private nurse.
Okay. It is your claim that the defendants owe you money for child care.
Yes.
How many children of theirs did you take care of?
One child.
How old is the child?
Christopher came at about 5 weeks old.
When did he come?
He came 7/27/01.
And for how many months did he stay with you?
15 months.
According to what I've read in your complaint, and there is a counterclaim, and the counterclaim is they want all the money back that they paid you, claiming some misrepresentation. Is that right?
Yes.
How many months in arrears were they? Because according to you, they were many months in arrears. Is that right?
Yes.
So she took care of your son even though you weren't paying her.
Yes.
Is that right?
Partial payments, yes.
Partial payments isn't payment. What kind of work do you do?
I'm working at a law firm. I'm a legal secretary.
Do you get paid every week?
Yes, I do.
How long have you been working at the law firm?
About 7 years.
Good. How much do you get paid every week?
1,100, I believe.
Good. And what would you do if for about 3 or 4 months the law firm only gave you $500?
It would be a problem. It would be a problem.
Why would that be?
Because I wouldn't be getting paid the full pay for the work that I'm doing.
Right. So why do you think it's okay just to give her partial payment? That's her job.
Well, we had an agreement with her, and she said that that was fine. You know, just make the payments what you can now, and don't worry about it down the line.
That would make her a really nice person, right?
Yes.
That would make her really special.
Yes.
Because you wouldn't stay with your law firm if your law firm said to you, you're only getting $500 a week. I know we're supposed to give you $1,100, but we're running into some tough time. I would like to see you say to them, well, that's okay. Give me what you can when you can, and then, you know, we'll make up for it at the end. You wouldn't say that to them, would you?
No.
You'd start looking for another job.
Yes.
So that Miss Jenkins was really nice to you. You love your son?
Absolutely.
He's your only child?
Yes, he's my only child.
So your only child, madam?
No.
You have other children?
Yes, I do.
How many other children do you have?
2 other children.
How old are they?
13 and 10.
So you haven't been a mother of a new baby for a while, but I assume you are devoted to this child. Is that right?
Yes.
And you wouldn't leave him any place where you felt as if he was being mistreated, would you?
No.
Came home every day and you checked him over. You didn't see any marks or bruises that were things that you questioned. Is that right?
I questioned a couple times.
Oh, well, you're not a neglectful parent, are you? If
No,
you question
just
them.
regular type of scrapes.
Regular stuff.
Mm-hmm.
Because you wouldn't let a child of yours stay any place where you felt as if the child was being not cared for.
Right.
Correct.
Is that right?
That's right.
So here we have a woman who takes care of your baby, your precious child, for 15 months. For a substantial part of that time, you are arrears in your payments. And this lady says, I know it's tough. Pay me what you can when you can. We'll catch up at some other point. And then there's a time when for many months she doesn't get paid anything, or very little. And her accountant sends you a what? A letter.
No.
She sent us a letter.
She sent you a letter. And what did the letter say?
There was a lot of...
What did the letter say?
That we owed $13.60.
$13.60.
$13.60.
That's all. Nothing about late fees or anything else?
Well, yeah, she said on there that if we didn't pay right away, then there would be late charges and, you know, those type of
Do you have a
court
copy
fees.
of that letter?
Yes.
I'd like to see it.
This was after we pulled him out, though.
Mm-hmm.
Miss Jenkins, not to worry. I will get to you if I need
Oh,
you,
no
madam.
problem.
Do you understand?
No problem, I do.
Good. Okay.
This letter was written...
Shh. All right. So let me highlight this for you. She wrote you this letter on October 26th. And at that time, Christopher was still with you? And
No, ma'am.
He was out?
Yes.
Okay. What day did you take the child out of her program?
24th, 25th
Of what?
September.
9/25. Okay.
That's when we all found out.
That's when you found out what?
That she had a family member in her residence that was accused and substantiated of child molestation of a child under her care.
So you took your son out on September 25th.
Immediately.
Good. Perfect. That's exactly what you should have done if that's what you suspected.
I got documentation.
Just a second. Precisely what you should have done. And then paid your bill. You went to work. While she was taking care of your child up until September 25th. There was nothing wrong with your child.
Yes, there was.
Oh, give me a break. You are so full of baloney. There was nothing wrong with your child because if you thought there was anything wrong with your child up until September 25th, you would have been a negligent parent. And your child should have been removed from your care, if you allowed a child to remain in a daycare situation, a 15-month-old, where you felt the child was being neglected or abused. So there was no question. You didn't feel as if the child was being neglected or abused, but you had good cause immediately, if what you say is true, and we'll get to that in a minute, to pull your child out, which you did. That doesn't mean, A, you get all your money back that you paid, because that's the most ridiculous thing I ever heard, and B, you're using it as an excuse not to pay your bill. She carried you. You're just being pigs. Now, let's get back to this person who you had working for you, or in the house. She's talking about a member of your family. Do you know who it is that they're referring to?
Yes.
Was anybody ever convicted of abuse?
No, ma'am.
Was there ever a trial?
We went to a hearing, and it was dismissed. I have...
Let me see the papers that you
that.
have.
It's in the file. It's in the backpack.
Oh, can we go get it?
Yeah,
Okay.
go get it. While she's getting it, I'm going to read a portion of this letter, and I want you to tell me if any part of this letter is not true. Pay careful attention. In your first paragraph, that's the letter that you wrote to her. You spoke of your financial obligations and hard times, and this is why you have continued not to pay for Christopher's childcare since April of 2002. Well, we all have financial obligations. However, first and foremost, there are three priorities as parents, childcare, and house payments and food. You have failed to keep your obligation to pay me for his childcare. You also swept him away by listening to others' lies and mean stories. Out of the kindness of my heart, knowing and believing that you would catch up with your payments, I kept Christopher for you. That's all true, is it not? Right? Because she could have said, I'm not taking care of him. You're not paying. You didn't pay me since April. April, May, June, July, August.
We made a payment every month. It was in arrears. So we did give her money every month. It just wasn't in full.
How much?
$200, $300.
And what was the whole tab for the month?
The whole tab was about $520.
So maybe you paid her half. Just like I said to him.
Right.
They only gave him $500 a week at his law firm where he worked.
That's right. And we trusted her. We felt very comfortable at that time.
She trusted you to pay your bill.
And we were.
You weren't.
We were paying.
You were not.
We had every intention to pay her.
Then you should have paid her.
Well, we've been making payments to her.
No, you should. You mean now? Last week?
I gave her a payment in October, November, December, and January.
Yeah, and there's more to
Just a
this that
second.
we found out.
What I want to know is if you're paying her, then you acknowledge that you owe her the money. Is that right?
We were not sure what we were going
Just
to
a
do
second.
about the situation.
If you acknowledge that you owed her the money by making payments since you took the child out,
right,
that's fine. Then why are you counterclaiming for $5,000 for all the money that you paid?
We feel that...
We paid money under false pretenses.
What were the false pretenses?
That there was spanking going on, there was humiliation, she wasn't taking, the kid wasn't under good
Then you
parents.
take your child out of daycare.
As soon as we found out, we did.
And you pay your bill.
We did.
I'm asking you why, if you acknowledge that you owed her the money, which is now what you're saying, which I find reasonable, why are you counterclaiming for $5,000 for all the money that you paid her?
I feel that my kid for the whole 13 months was in
Excuse me?
danger. I feel my kid was in danger the whole 13 months.
Then you're a fool.
Well, when we found out...
Then you're a fool. Then you didn't do your homework.
Well...
Then you're a fool.
We
But
relied
just like if your boss said, you are the worst paralegal that I ever had, and I'm firing you. And not only am I firing you, I am suing you for all the money that I paid you over the last 2 years because you have no talent. That's really what you're saying. That's really what you're saying. You're saying that because you found out later something that you didn't like, you're entitled to all your money back.
Yeah,
that's what you're saying. You tell me the difference between that and my saying to you.
Someone was a convicted molester.
She wasn't a convicted molester.
But
she did
things. She spanked. She humiliated. These are things that were found in a decision.
Then you should have been more vigilant. That's your problem. You got the service. She took care of your baby so that the two of you could go to work. Right. And now, after 15 months, you say, now I'm going to do the homework that I should have done before and look into things, and now I find that I don't like what I'm reading, so I'm entitled to all my money back. No. And there's no difference in that by your boss saying to you, you are the worst employee. You did no work for me that I could use. Therefore, I want all the money back that I paid you for the last 2 years. You don't eat the food and then say, I didn't enjoy it, I'm not paying for it.
Judge Judy continues in a moment.
If he wasn't convicted, then why is he not allowed on her property?
Get a life. Your child enjoyed the service. You enjoyed the service. You took him out because you were concerned. That doesn't mean you don't pay. You pay.
Real cases, real people. Judge Judy. Child care provider Mary Jenkins claims Cynthia and Tom Wyatt owe for unpaid babysitting fees.
Can I please see the report from the state? The last report from the state.
You want to see what?
I want to see what papers that suggested that he was never convicted.
There's case dismissed.
Can I see, please? Thank you. This is a juvenile court case.
He was a juvenile. He was only 10 years old, Your Honor.
Just a second. Is what you're telling me this incident happened when he was 10 years old?
My sister made an allegation, and she just, whatever, and
okay.
We had to
You're talking about something that happened when he was 10 years old, and the case was dismissed.
Yes.
Is that right? Is that what we're talking about?
If he wasn't convicted, then why is he not allowed on her property?
And it was substantiated that there was molestation.
This petition was dismissed. Now, I want to see the last report from Child Services. Are you still licensed?
Yes, ma'am.
Can I see your license?
This is from the police department saying there's all the accusations are unfounded.
Can I see, please?
This is one of the allegations was that he was not fingerprinted. He was fingerprinted.
License.
Yeah.
Just so that you have an active license, because I'm sure that
that's
the why
my
it's called
license.
social
That's still
services.
in effect. As far as credentials, I have trust line clearance. I want that other one.
This says dispatch location regarding possible child abuse investigation. It was determined the accusations were unfounded. Okay. Then we have a letter here dated 12/20/02.
Restrictions.
Okay.
It's a red folder.
For your request, we made a review. On 10/25, your facility was cited for not having fingerprinted as required by Title 22, and you were assessed a penalty of $100. The results are as follows. The penalty assessment is dismissed, and the explanation is your appeal request concerning the dismissal of the civil penalty of $100 is being granted because at the time of the visit, you had already submitted fingerprints so that was, in fact, dismissed. And I have a license. The effective date of this license is 5/7/01, and you can have 12 children with no more than 4 infants. And are you still licensed?
Yes, ma'am. Here's a
Can I see it,
letter
please?
from the Department of Licensing. Shows there's no restrictions on their behalf.
December 17th, 2002. This is to confirm that there has been no action by Community Care Licensing that restricts this license or prohibits Ms. Jenkins from accepting children for care at this time. That's it.
This was issued on January 3rd.
Can I see it? January 3rd of 2003.
Yeah. 2003.
Good. I'll read it.
And the whole
I don't.
13 months, he was in and out of there during all the holidays. There was times where he was down for 4 or 5 days, January, February.
Get a life. Your child enjoyed the service. You enjoyed the service. You took him out because you were concerned, which is exactly what you should have done as concerned parents. That doesn't mean you don't pay. You pay.
Okay.
All right.
So I assume that you followed this up with the state. Is
Find
that
out
correct?
what was going on, yeah.
Is that, just to answer my,
Yes.
I assume that you followed it up with the state, so that the state finally said that this young man cannot have any contact with children at your facility. Is that correct?
That's what that was at that time, yes.
Has that changed since January 3rd, 2003?
January 3rd. We chose not to until everything is cleared. Even at that, he was not an employee or ever will be an employee.
Okay. How much do they owe you, still owe you?
Less the 3 payments, $25.
They owed you $13.60, according to your letter.
Yes.
Less $75?
Yes.
Go ahead.
And then I told my accountant to please note that if she does not pay, that we could just attach the $25.
Well, you sort of forgave that, you know, when you gave
Right,
when you
that's
gave
fine.
them an opportunity, when you gave them an opportunity to pay you out, you know,
That's
when
right.
you were nice enough to do that.
Your Honor,
Yes.
why I gave her an extension, it seems crazy, is that prior to this, she gave me about 3 months in advance. And I thought, you know, that's pretty good. Somebody must really care and love me enough and trust me with their child to give me 3 months
In
not
advance.
In advance. So if she gave me 3 months in advance when she was buying a house, I said, no problem. As long as I have children that pay, they hold over. I can buy the food and run the facility.
Judge Judy continues in a moment.
Bottom line, you have an absolute right to take your child out of a daycare situation where you feel that the child may be threatened. May be threatened. I assume that there was never any physical indication that you had with regard to your son's care, and I assume that you were vigilant when you went to see him. I assume that you did what most parents do. They come, they observe what's going on, they make surprise visits. I'm sure that you're not foolish enough not to have done that. You left your child there for 15 months. You found out subsequently that there were things going on there that gave you cause to pause, so that you do what a normal person does under those circumstances. You take your child out. Then you pay the bill. And the bill is $1,285. And that's what you're going to pay. And your counterclaim, your ridiculous counterclaim for $5,000 for the money that you paid is dismissed. Goodbye.
All are excused. You may step out.
As soon as we suspected something, the day we found out, we went, left work, and we picked up our child.
It's all over money, and it's sad because I dearly love the family.
We felt we signed a contract under false pretense, and she didn't, do her obligations under the contract and take care of our kid.
The dad used to turn around and say, you know what, I've got to thank you. I go to work very, very comfortable knowing that Christopher is in your hands.
And now the next case.
All parties in the matter of Hill versus Peto. Step forward, please.
Food clerk Lori Hill is suing her ex-husband, maintenance technician Dennis Peto, for the return of child support. Dennis says Lori still owes him for an unpaid medical bill.
Ms. Hill, you and the defendant have 2 children together, 2 daughters.
That's correct.
And according to your complaint, both of the girls were living with the defendant. Was that by court order?
Yes.
How long had the children been living with the defendant?
About 8 years.
And how old are they?
15 and 12.
What are their names? 15-year-old.
Teresa and Amy.
You were ordered to pay child support to the defendant for the 2 girls.
That's correct.
According to your complaint, there came a time when one of the girls came to live with you, and there was an agreement that since there is sometimes a lag in the accounting through the court, that any money that you paid after your older daughter Teresa came to live with you would be returned to you. It is your claim that Mr. Peto owes you $303. Mr. Peto says that you actually, despite the fact he doesn't have a counterclaim, owe him for a medical bill for one of the girls. Is that right, sir?
Yes.
Okay. the children had been living with Mr. Pito for 8 years. Did you have visitation with the girls?
Yes.
And under what circumstances did Teresa come to live with you?
I had a lady from Protective Services show up at my door. There had been a conflict at their home, and I was under the impression Teresa was hit, and that's why she came to stay with me.
What was the amount of the support that you were paying for the two girls?
$102 weekly.
How long had you been paying child support?
For the whole time that he
For
had
the whole
him,
8 years?
yes.
Did you have a discussion with Mr. Pito with regard to the child support when Teresa came to live with you?
Yes, he, when he dropped her stuff off at my home, he had this paper for us to sign.
May I see it, please? Thank you. Okay. You say you'll waive the $104 in child support. That means that each of you was going to take care of one child, and there would be no support paid by either one. Is that right?
That's right.
And that is dated 12/4/01. Was any money taken out of your check after the 4th of December?
Yes, I have all my...
Is that the $303?
Yes.
Do you acknowledge, Mr. Pito, and let's not get to the medical yet, that the plaintiff paid child support beyond whatever these debts are of $303 that you received after December 4th?
Yes, I do, Your Honor.
Okay. Now tell me why you think that you shouldn't have to give that back to her.
Well, Your Honor, when I made that agreement with her, after that, I realized there were still pending medical bills from when Amy had her asthma attack on September 2000, and there was a $1,700 bill. And at that time, she was still required to pay 36% of that $1,700. And after talking to the medical staff that was billing me, she told me that most of it might be taken care of, but at the very least, there's still going to be a $212 balance.
What do you mean most of it was going to be taken care of? What does that mean?
Well, because between her insurance and my insurance, they're trying to see who's the primary and who's the secondary. And before that's settled, and when I have to pay the bill, I want to make sure that she doesn't have any more outstanding bills.
So what you're saying is you signed this document, and afterwards you realized that there may be some money owing for a 2-year-old medical bill because the insurance hasn't been sorted out yet. Is that right?
That's right.
Mr. Pito, when you get your act together with regard to how much money you think Ms. Hill owes you, and all the insurance claims have been submitted and ultimately resolved, you have the ability to go in and file a claim against her if she still owes you any money. In the meantime, you have to return the $303 that you accepted from her after you signed this document indicating that you would not be taking any money from her. She would not be asking you for any money. You were both going to assume full financial responsibility for each of the girls that were in your custody. Okay? Now, that's easy. Do you see your daughter, Teresa?
No, Your Honor.
Why not?
Well, she lived on bad terms, and until she gets her act together, Your Honor, I don't want her in my house because she's a danger. She's
15 years old. How's she behaving in your house?
She's a handful.
She's a handful.
Yes, she is.
I've got a feeling that you got the easier end of the bargain at this point. Is that right?
Your Honor, I've had custody for those girls for 8 years, and the reason for me having custody because she attempted suicide in front of my children.
No, don't go back 8 years. Right now, you have a 15-year-old daughter who had been with you for 8 years, and she's going through a teenage rebellious period of time. So all I said was that right now, you have the 12-year-old who's okay?
Yes.
So far?
Yes.
Right? Got the easier part of the bargain. Give her back the $303. That's all.
Oh, you got excuses. You need to step out.
I had no idea I owed any medical bills. This is the first I've heard of it.
It's hard to pay her back money when I know I still got money coming.
I feel sorry for her daughter. She's been getting in a lot of trouble, but, you know, she really needs her dad. You know, she loves her dad, and it's just too bad they don't speak anymore.
And now the next case.
All parties in the matter of Caban versus Reyes. Step forward, please.
Hairstylist William Caban is suing his former friend, 25-year-old waiter Jeffrey Reyes, for an unpaid loan to bail him out of jail.
According to your complaint, the defendant owes you for bailing him out of jail.
Yes.
Tell me exactly how that happened, sir.
We went out on Thursday night to karaoke. And
What was the date?
May 16th. And one of my friends met me at the bar, and he wanted to leave. I asked Jeffrey, do you want to go? He says, no, I want to stay.
Your Honor, he left me there.
Just 1 second. I'll get to you. Go ahead. Get to you. Go ahead.
And I said, do you want to come? He said, no, I'm going to stay here. I want to sing. So I said, okay, I'll do you a favor. I gave him my ATM card. I gave him $20 plus my car keys. And I said, I'll talk to you later.
ATM card for what?
To drink. He didn't have no money.
Mm-hmm.
And then the next day he calls me and said, he's in jail, to bail him out of jail.
That's not true, Your Honor.
I said,
Mr. Reyes, could you wait until I look at you and ask you questions, please? Now look at me. Could you do that?
Yes, ma'am.
And what did he say to you?
He said, Will, can you please come and get me out of jail? Do you have the money to get me out of jail? And I did not have the money to get him out of jail. I had to go running around town, borrow money to get him out, because he kept on calling me every 15 minutes that my cell phone died and his cell phone died. There's 3 cell phones in the car, and they all died because he was calling us so much.
What do you mean 3 cell phones in the car?
We had 3 cell phones in the car. There's 3 people trying to get him out of jail. The only one that got him out of jail was me.
Well, who else was in the car?
Another friend of his roommates. I don't know his name.
So you're driving around with 2 other friends in the car?
No one had money to get him out.
Just answer my question, sir. You're driving around with 2 other friends.
Mm-hmm.
We're going to do this my way.
Okay.
Do you understand? Because my way, I'm going to get the truth.
Okay.
Where were you going?
We getting money to bail him out of jail.
And when you bailed him out, what did he say to you?
He said to me, thanks. And I said, you need to pay me back.
And what did he say?
He said, yes, he'll pay me back. And I stressed it to him. I need this money back.
All right, Mr. Reyes, now I'm going to hear your version of the events, sir. What were you arrested for?
Driving with a suspended license.
So I gather you took the car keys and went home.
I stayed in the bar till 2 o'clock in the morning till they had last call. They did not come back. He had left his keys on there. He did not tell me he was going. They both just left. So how am I supposed to get home? I took the keys and I drove home. Then I went home. There was a cop already there. They had my name on a piece of paper like someone had called the cops on me already. So I went there. He asked to see my driver's license. I showed him my driver's license, and he took me to jail.
Then you called him.
Yes, I called him.
And what did you say when you called him?
I said, Will, what happened yesterday? He goes, oh, I left you the car. He said, I didn't come back yesterday. He said, why, where are you? I said, I'm in jail. He goes, oh, don't worry, I'll get you out. He said, don't worry about it. Trust me, I'll get you out. I don't have the money to pay him back. I didn't ask him to bail me out. If he bailed me out, it's because he felt sorry for leaving me with the car. He knew I couldn't drive with a suspended license. I didn't want to drive.
Why was your license suspended?
Not paying a ticket. And I got pulled over before, and he gave me a ticket for driving with a suspended license. And he said, next time you will go to jail. So I didn't want to drive.
Where do you live?
I live in Orlando.
And is that where the karaoke bar was?
Yes.
Now, Orlando, Florida is a major metropolis. I've been to Orlando, Florida. Do you know what they have in Orlando, Florida?
Disney World? I don't know.
Do you know what else they have in Orlando? Taxi cabs.
Your Honor, I had no money.
Your Honor, I left him with money.
Shh, just a second.
I left him set.
Just a second.
All right.
Yeah, by the time the bar was closed, I was broke.
Mr. Reyes, that's what you call lack of planning, sir. Because if you were waiting for him and he didn't come back and he left after 20 minutes, something should have gone on in your head that said to you, maybe I am stranded here, so I better take the $20 that he gave me and put a couple of dollars away so that you could call a taxi cab to take you home, since you didn't have a driver's license.
I understand what you're saying, Your Honor, but he left me an ATM card. Taxi cabs do not take ATM cards.
And $20.
He had an open tab on the bar. When it closed, it was closed with $20 I had spent drinking.
What happened as a result of that case, Mr. Reyes?
They gave me day served.
And a fine?
Yes.
How much was the fine?
The fine was $500.
Did you pay the $500?
Yeah, they took it out of his bail.
Out of my bond.
They took it out of his bail?
Yeah.
Oh. Judgment for the plaintiff in the amount of $560. Mr. Reyes, have to take responsibility for what you do, sir. You had a lot of choices. You picked all the wrong ones. That's all.
Okay.
Parties are excused. You may step out.
He just wanted the money right away, and I couldn't give it to him.
Been given the runaround.
Maybe he called the cops. I don't know. I don't know what the whole deal was.
I gave him my car. I gave him money. And that's the story.
And now the next case.
All parties in the matter of Parker Cruz versus Bumpers. Step forward, please.
20-year-old student Brittany Parker and her friend, 19-year-old student Nil Marie Cruz, are suing boxing coach Jada Bumpus for a refund of the money they paid for boxing lessons.
All right, you two ladies go to college, is that right?
Yes.
And you decided to sign up for some boxing lessons for exercise with the defendant. One of you paid in full $150. Which one was that? And you are?
Brittany Parker.
And Miss Cruz, you didn't pay the $150, you paid $100.
Yes.
And you told Mr. Bumpers that you would be giving him the other $50 when you came back. Each of you took one lesson, and then you decided not to continue for whatever reason, and you want your money back.
Yes.
Defendant says, no way. Aside from everything else, you stood him up for about 4 classes. Is that right?
Yes, ma'am.
Okay. When was your first boxing lesson?
November 7th was a Wednesday.
Do you have a contract with the defendant?
We didn't sign any contract, but we had receipts.
Was there any conversation about the 10 lessons? How many lessons you were supposed to take within a certain period of time?
We figured that we'd do it every Wednesday and Friday at 4 o'clock.
And you were supposed to be there on Friday?
Yes.
Did you go?
No, I called them at 7 that morning because I had a family emergency that sprung up on Thursday, so I had to be home.
What kind of an emergency?
Well,
not well. What kind of an emergency, Ms. Parker?
my family was going through a divorce. Well, my parents were going through a divorce at the time, and I had to attend to my mother's needs.
The following Wednesday, did you show up at 4 o'clock?
Yes, we both did.
Did you take a lesson?
No,
Why not?
because he wasn't there.
Why weren't you there, Mr. Bumpus?
Because the class was scheduled for 3:30 to 4:30 was the agreement. This 4 o'clock is very conveniently, they've come up with this time. It was scheduled from 3:30 to 4:30, and we agreed that it'd be twice a week. Because I gave them a big discount, I usually charge $250 for 10 private 1/2 hour sessions. To college students, I charge $185 because they're college students. When Brittany Parker called me, it was 7 weeks after September 11th attack. Business was slow. I said, I'll give you a $25 discount if you sign up right away for $160. She said, well, I got a friend that wants to sign up. Well, what if the two of us sign up? So I said, well, you bring me $300 and the two of you can sign up.
Does that sound right?
All but the time. I'm not sure if it was at 3:30 or 4.
So you're not sure?
Well, it's been a while. This was back in November.
Well, if you're not sure, then he knows, and it was at 3:30.
Whatever time it was, if it was 3:30 that we were supposed to meet him, that's what time we were there.
You don't know that at all. So did you call him when he wasn't there?
Yeah, I called him right away when we were standing at the gym waiting for him.
Did you reach him?
Nope. Voice left a message on his answering machine.
When did you next contact Mr. Bumpus?
I finally checked my my email that day or night, and I found the emails that he sent me over the weekend after the Friday class that we missed.
Well, can I see those emails?
Yeah, I have them all here. The first one is the introduction to his program.
No,
It's about 3 pages long.
Mr. Bumpus, I'd like you to take a look at this email, please, and tell me if you recall sending it.
Okay. This may be. It looks.
It was a message that you sent, sir. I have the other email
yeah,
here.
it looks like.
Okay, so let me get the time frame correctly. Give me that back, please. Time frame is they come in and they start and they take one boxing lesson on Wednesday, November 7th. They were supposed to come back on the 9th for another lesson and didn't show up.
Right.
Right? You didn't show up. Now, he's entitled to be paid for the 9th when you didn't show up. He was waiting there for you. He says he didn't get the message. You didn't reach him. You may have called him in the morning, but you didn't reach him. Is that right?
No.
No. But then, come Wednesday, he says you're supposed to be there at 3:30, and he indicates that in the email. He'd like to see you between 3 and 3:30. But on Tuesday, sir, the day before, Tuesday, you've already sent this rather nasty email.
Can I explain it?
Well, you sent them.
Can I
you
explain
sure
why?
can, but let me tell you
Okay,
what
go
you
ahead.
said. You said in the email, the price of my classes is $185. You bargained me down on the premise that you would each give me $150. Then Nell Marie showed up with only $100, promising to bring the rest on Friday. Without an utterance from her, you called at the last minute and claimed that the two of you would be seeing me the following lesson tomorrow, Wednesday. And then you write in block letters, wrong. I can't and won't do business like that. Neither of you have shown an ounce of integrity in my dealings with you. Unless you can assure me that you'll give me $10 and Nell Marie $60, the original charge of $160, then I won't give you classes until you meet your obligation, period. So you changed the contract from $150 to $160 in here. I expect to hear from you by tomorrow morning. Otherwise, don't expect to see me. That's a pretty nasty email from a businessman. Go ahead.
They lied. Number one, she didn't call and leave a message at my house at 7 in the morning. I hadn't left. When I got back from Amherst, my tape machine said 1:20 in the afternoon.
I just said to you, sir, she has to pay for that lesson.
No, but I'm just saying.
Now listen
this,
to me.
Okay.
They have to pay for that lesson.
Okay.
They stood you up. If you say you made the trip, they're going to pay for that lesson.
But that
doesn't explain this
the
kind
anger
of email.
the anger is now she had the family emergency as she presented, but it was Nilmari who didn't have my money. She was going home because it was like Veterans Day weekend. Now the story has changed that she had family problems.
I don't
And
even know if she had
Nilmari-
family problems.
That's what got me so upset, because it was a game, because we had gone over a 2-week period for them, finally getting them to meet me. I don't have time for games. I've trained hundreds of people at that school. I've never had an incident like this. I
can't believe that, sir, when you deal with college students, that you haven't had an incident like this.
Not like this. I haven't, I'm telling you.
This is not bizarre. It's two college girls. One decided to go home for Veterans Day weekend. The other one didn't have the other $50. You, however, Mr. Bumpus, and I'm not excusing that, they were a little irresponsible, and they didn't, they didn't respect your time.
But I took away the anger in a future conversation.
I don't care whether you took it away or not. This said, now I'm changing the contract. It's not $150 anymore. Now it's $160. Well, you've already got a lot of their money. Far more than you've invested in the boxing lessons, sir. Far more.
Well, that's a matter of what you think value is. I tell everybody that signs up with me, the first class really is what you're paying for. The rest are free, because you learn so much in that first class. They learned things that they wouldn't have learned in 6 months in the average boxing gym. And that's the bottom line.
Just figure this out. $150 divided by 10 lessons equals $15 a lesson per person.
Numerically,
They took-
I understand. Yeah.
That's my job here. I'm not really good at numbers, but that's what it is. It comes out to $15 a lesson for 1 hour. Miss Parker paid you $150. She took one lesson. She missed another lesson that she had scheduled, and I don't find there's any valid reason, because I think that this is all a lot of baloney, this other reason that you gave me, which means that Mr. Bumpus owes you, if you canceled, $120. And the reason I say that is Mr. Bumpus, in his email to you, changed the contract from $150 to $160, and he can't unilaterally do that. So Mr. Bumpus has to refund to you, madam, $120. And he has to refund to Miss Cruz, who only paid $100, and who also, for no valid reason, skipped a class when he was there waiting for you. He's entitled to be paid for his time. He's got other things to do with his time. And you're entitled to $70. Miss Parker, I don't know what statute you're looking at that says you're entitled to treble damages, which you're suing for. Triple the $120.
Under the 93A Massachusetts law.
You're not going to get it.
That's
you have
fine.
to act responsibly.
But that's under the law. That's why I had legal advice to do that.
All right. Well, your legal advice was wrong. You have to behave responsibly in order to avail yourself of a claim that is punitive against him, giving you triple the amount of damages that you're suing for. And you two girls did not act really responsibly. You know, you have to start to value other people's professional time. And his time is his money. So you have to act responsibly. You are entitled, however, to a refund in the lessons that you didn't take because Mr. Bumpus changed the terms of the contract. That's all.
Parties are excused. You may step out.
They both lied so much.
I called just as much time as I had noticed.
iBox Amateur and Pro was managed by former champion Joe Frazier.
I was irresponsible and I'm at fault for that.
My youngest daughter is squad with Jackie Frazier.
I'm just happy it's over and we got our money back.
I've never had this. I've trained 1,100 people, probably 700 students, probably 200 women. Most boxing coaches don't even teach women.
And now the next case.
All parties in the matter of Gomez versus Todd. Step forward, please.
Homemaker Bonnie Gomez is suing her daughter's ex-boyfriend, 21-year-old appliance salesman A.D. Todd, for an unpaid loan for bail. A.D. says he never asked Bonnie for help.
Mrs. Gomez, the defendant was dating your daughter. She was 17 at the time, and according to your complaint, he got himself arrested, called you, begged you to bail him out of jail. You did. It was a loan, and he hasn't paid you back.
That's correct.
When did he call you and tell you that he had been arrested?
He called me on June 20th, about 10 p.m.
And what did he say to you?
He said that he had gotten himself arrested for a mistaken identity, is what he told me.
He got himself arrested for a mistaken identity?
Mm-hmm.
I didn't know the last time I looked in the penal law that that was a crime.
Yeah, I didn't either. So he asked if I could bail him out, and his words were, "Miss Bonnie, please, I can't stand it here. Please bail me out."
Your Honor, she's lying.
Did I ask you anything yet?
No, ma'am.
So I asked him how the bond system worked, because I'm not familiar with how jail and stuff works, and he says, well, if you put up the bond, you get the money back. So I spoke to somebody at the bond company, and they said the way it works is that they put up a big bond for him, I pay some, but I don't get it back. They get their money back if he shows up to court. And so I hesitated, and they said, well, we have 2 other bonds out on him, so he's a good risk, he will go to court. And I said, well, let me think about it. And he
Did you know at the time that he had been arrested at least twice before?
No, I did not.
What was he arrested for this time?
Well, what he told me originally was that it was mistaken identity, and after I bailed him out, he told me that his girlfriend, the mother of his baby, had said that he had beat her up. Come to find out later on, when I went to get a copy of what he was arrested for, he was arrested for possession with intent to distribute and criminal impersonation.
Drugs?
Drugs, yeah. And I supposedly, from what I understand, impersonating a police officer.
Okay. So you posted his bond?
Yes.
$1,500?
Right.
Did you ever get it back?
No.
Did you ask him for it back?
When I bailed him out of jail that night, I said to him on the telephone before I went to the jail, I said, you know, I need this money back. I'm a single mom raising 5 kids. You know, my health hasn't been very good for a few years. I haven't been able to work. What I have is in my savings, and that's what I'm supporting my kids with. And he says, Miss Bonnie, I have the money. I just have to go get it. As soon as I get you, you know, you come and get me out of jail, we'll go get the money. I said, okay, fine. And I said, would you sign an IOU? And he said, yes, I will. He says, I'll sign whatever. You want to put interest on there, whatever, I'll sign it. So went ahead, went over to the jail, signed him out of jail, wrote a check out for what it cost to get him out, the $1,500. It was about probably 2 to 3 o'clock in the morning at this point. And he says, you know, Miss Bonnie, it's a little late, you know, to go over to my friend's house, so let's just wait till the daytime. And I said, that's fine, you know, because I was pretty tired as well. And come the next morning, you know, a few hours later, I made him sign an IOU, which I can't find now, it disappeared. And he left and haven't seen him since.
Real cases, real people. Judge Judy. Bonnie Gomez says her daughter's ex-boyfriend, A.D. Todd, owes for an unpaid loan for bail. A.D. says he never asked Bonnie for help.
Where were you arrested, sir?
At the apartment that I stayed at.
What were you arrested for?
Possession.
Possession of what?
Marijuana.
That was at least the 3rd arrest that we know about, because you'd been bonded twice before. What were your prior arrests?
Harassment and driving without a license.
You don't get arrested for driving without a license, sir.
Well,
bonded.
in Colorado, if you ain't got your license and insurance, you do go to jail.
Uh-huh.
Right. Okay, but anyways, Your Honor, when I went to jail, I called Mrs. Gomez's daughter. I asked her, would she go and tell my mom to get me out of jail? She said, all right. That's the last time I ever called her house. 2.5, 3 hours later, there was somebody bailing me out. They told me to pack my stuff. You know, I gas out. You know, Erica was sitting there, and I didn't know who Miss Gomez was at the time because I never met her. So I signed the bail bondsman papers. Miss Gomez leaves out with us. And we gets to her house, you know, because I stayed like 2-3 blocks away. You know, and I'm talking to her. You know, next thing you know, I goes home that night, and I comes back the next day. And she tells me, well, Mr. Todd, you know that you're going to owe me $1,500 for getting me out. I'm like, you know, shocked. I didn't think I owed her anything. I mean, I didn't ask her to bail me out of jail. She did on her own. I mean, if her daughter did, then that's on them. That's not on me. But I was dating her daughter at the time, you know, and I guess I picked up responsibility and said, okay. You know, so like 2, maybe 3 days later, I had like a really bad necklace, you know.
Like a really bad necklace? What was wrong with it?
No, I mean, I had like, I had a nice, really expensive necklace. It was Pegasus. It was about yay big. And
probably cost $2 at a flea market.
yeah, it had like 2.5 carats worth of Marquise and Big Ed diamonds in it. I mean, it wasn't like Cuban zirconia. It was retail price of like $15,000, and I gives it to the plaintiff's daughter, and I never seen it since then. You know, I never called the house again, and Ms. Gomez never said that I owe her any money. She never brought the subject up to me. You know, everything was all right from what I knew. I say about a month and a half later, me and her daughter still talking. You know, I comes back from the store. It was me and my little brother and my baby's mom. And we gets out of the car, and this white car pulls up. Miss Gomez is in the passenger seat. Then a bunch of little Mexicans get out the car and try to beat me up. You know, taking off their shirts, saying, "What's up, Holmes? You know, is this him? Is this him?" I hear a lady in the background saying, yeah, that's him. You know, so they run up to me, and I'm taking off my jewelry so I can, honestly.
You wouldn't mind showing me that jewelry, would you, sir?
No.
Could I see it up here, please, Bert? Would you get that for me?
You want to see what's on my neck, too?
No, that's what you're going to give Bert is sufficient. Keep talking, Mr. Todd.
Okay.
I'm fascinated.
Okay. But anyways.
No, really, really.
Okay.
No, I don't know. Please don't laugh. I'm fascinated.
Okay, but after the little essays run up on me and try to beat me up, you know, my little brother goes in the house and gets my mom. You know, she gets out of the car. My mom says, you know, what's going on? My mom didn't even know who these people were. Miss Sanchez get out of the car, and she's like, well, your son owes me $1,500. I'm just looking like, I don't owe you a thing, you know. Never once did I get told that I owe you any money. You know, so after that, you know, I never seen Mrs. Gomez again. You know, after I gave her the necklace, it was like, I guess everything was okay.
So what you're saying is you gave her daughter the necklace to pay off this debt? Is
Yeah,
that what
she
you're
could have
telling
took it to any pawn shop.
Is that what you're telling me?
Yes, ma'am.
Mr. Todd, usually when you go to court, you get all dressed up?
Yes, ma'am.
Put on your finest, right?
No. It's not my finest.
You have better.
Yes.
Really? Have better clothes?
Yes.
Have better jewelry?
Yes.
Where's your better jewelry?
This is like from way back, before I even moved to Colorado.
I'm talking about this jewelry.
All this stuff is old. I had this stuff for a long time.
Because one would think if you were wearing all this flashy junk that that this would be your best stuff.
No.
Right? No, the best stuff you gave away to her daughter. The one with
It was one of the best.
The $15,000
Yes, ma'am.
piece.
It was one of the best.
Wasn't any junk like this. Wasn't any
No,
glass like this, you
No,
know,
ma'am.
in whatever kind of metal this is.
All right.
Right?
Right.
It was a really good one. Gold
ma'am.
and diamonds and
Yes, ma'am.
and well-cut stones that was worth $15,000. Where did you get $15,000 from?
Family.
From your family?
Yes. My dad had bought the necklace for me at the time.
Really? He must love you very much. Must be very proud of you.
Yeah.
You owe her $1,500. Listen, you get yourself arrested. She's nice enough to come at 2 o'clock in the morning, leave her 5 children to come and pick you up, and you're doing a dance? Do me a favor, return this garbage to him. Judgment for the plaintiff in the amount of $1,500. That's
Thank you.
Advisors are excused. You may step out.
Well, I'm just glad that everybody in Colorado knows what kind of person A.D. Todd is.
I just don't think she heard my side, and never once did I ask her to get me out.
If you borrow something, you need to pay it back.
Don't trust a woman.
Just let them stay in jail. Obviously, they did something to get themselves there.
Board your horses with the defendant.
Yes.
Your Honor, may I speak?
It didn't work out.
Oh, it's way more than didn't work out.
You're really being so annoying to me. So far, you're not losing. The only thing you're losing is my patience.
This is Judy Just. Gabrielle and Angela Alfredson are suing their stable landlord, Glenn Garatiano, for rental fees after being forced to move their horses from his property.
Court come to order. All rise.
Have a seat, please. Hello, Kevin.
Good morning, Judge. Case number 3028, Alfredson versus Gertard.
Thank you.
You're welcome.
I'm going to speak to you. What's your first name?
Gabrielle.
Gabrielle, this is your mom, and you had horses.
We do, both of us.
How old are you?
21.
In what month and year did you start to board your horses with the defendant?
February 2023.
And where had they been prior to that?
Charlotte, North Carolina, where I lived before moving to Charleston.
And your mother?
And she still lives in Charlotte. She has plans to move to Charleston.
How many horses did you have?
I have one and my mom has one.
But you took both of them with you.
Yes.
Tell me why.
They've been together for over 6 years. This is something we do together, me and my mom. And since she had plans to move, we didn't want to stress them and separate them. So we wanted to keep them together.
Okay. When you moved with the horses, you were the person who found the property?
Correct.
And did you meet with the defendant?
Yes, I did.
Did you ultimately sign a lease with him?
Ultimately, yes.
When? Month and year?
It was beginning of February 2023, I believe. I have the lease.
I'd like to take a look at the lease.
It is on my phone through emails.
I want to look at the lease.
I have it, ma'am.
Oh.
Would you like a copy?
Yes.
These are copies of all the documents I'll be speaking about today.
I don't want to see all the documents. I want to see the lease.
Coming up, Exhibit B.
Thank you. Okay. Your lawsuit today seeks recoupment of certain monies that you paid pursuant to this lease. The defendant has a cross-complaint for damages that your horses did to his property, which is also included in the lease as your responsibility. So the lease started February the 12th. When did you move your horses there?
The night of the 11th.
And where did you put them?
In the pastures on Glenn's property.
Was he there?
He was. He came out and told us speaking,
So you were there with your mother?
Yes. It was me, my mother, and my father.
And there were no incidents. Did he explain to you what had to be done? You have to water them from a certain trough.
Mm-hmm.
Did he explain all that to you?
Yep. He said he has no knowledge of how to maintain and care for horses. That was all on us. As long as we pay our rent and take care of everything, that will be that.
Okay. So that's February. How much money did you pay him in February?
$925.
For the two horses?
Correct.
Were the horses there in March?
I think it was when we moved in beginning of March, or middle of March.
Do you remember the date?
Yes, ma'am.
What was the date?
The 13th is when they actually came with the two deputies to take their possessions.
So they were there for a month?
5 weeks. She was supposed to come in mid-January, but postponed.
Just a second. The lease says it starts February the 12th.
Correct.
That's what the lease says. They left March 13th.
Correct.
Okay. And you paid the defendant how much?
3 payments of $925.
Okay. February, we have $925.
Correct.
And you are several days over into the second month. Did you pay the second month?
We did initially.
You made 3 payments. I'd like you to explain to me the third payment.
We had to pay the first month of board, which was the $925, then the $925 for a deposit.
Okay. So a $925 was a security deposit.
Correct. And then an initial $925 for the first month of February.
Okay. So $925 was a security. Is that correct?
It is correct.
Okay.
It was not paid at the proper time. Neither was the first lease payment.
$925 was security deposit.
Yes.
2 months board.
Correct.
Now, it didn't work out.
Oh, it's way more than didn't work out.
I just said, I don't care. Actually, the idea is to keep it simple. It didn't work out. You were happy to see them go?
I initiated termination in the lease pursuant to the
And
lease.
they were happy to go?
Apparently, yes.
So now it's a matter of money. That's all it's about. I mean, you're not married to each other. You don't share grandchildren together. So it's a matter of why they don't get their security deposit back. Do you understand? You stayed over the second month, so you had to pay the second month, but $925 is security deposit. And there's no reason, unless there was some sort of violation of the lease, why you're not entitled to the $925 back, which is your security.
There was also criminal animal abuse during the 5 weeks that they were there.
Just to say, what does that have to do with this lawsuit?
It has to do with why their lease was terminated.
I don't care.
Okay, that's fine.
They want their money back. They don't want the pasture back. And I understand from your papers you believe that they weren't adequately caring for the animals, and because they weren't caring for the animals ate up your pasture. I don't know. You're going to show me what you're alleging in order to avoid returning their $925 security deposit.
That's part of it.
Ball's in your court.
Okay.
Security deposit. 925 security deposit, to which they would otherwise be entitled to unless you have proof to me that their horses damage your property.
So you want to go directly to the damages?
I want to go directly to the damages.
Okay,
I
heard.
This is my life. It's fleeting by so fast.
Someone please give this to
I
the
just
judge.
want you to show me what the damage is.
Okay. I guess I'm not going to refer to my notes. I'll just do it on the fly. Okay. The very first.
Shh.
Oh, don't explain?
No,
Sorry.
I don't want you to explain anything. They're pictures. Oh, there's something in the packet that you just gave me. Would you please show this to Gabrielle and ask her if that's her signature?
Your Honor, may I speak?
Shh. No.
That means no.
That's a no.
Okay.
Is that your signature is my question.
Yes.
Okay. When did you sign that?
The day we left.
The day you left?
Correct.
Okay, and this shall serve as your receipt for the month's rent of $925 and the deposit $925. It will also serve as a receipt for your final month's payment of March 2023. We have agreed that the deposit is forfeited to cover some of the damage done by the horses, right? And you sign that?
Correct.
Well, then you have no case. What do you want?
I want to tell you my side, please.
You want to tell me about what?
This whole incident.
I don't care about the whole incident.
Your Honor.
Okay.
Just a second. You don't understand. This is a contract. She signed a lease as a contract. She's 21 years old. In order to leave, you left. You were both happy to be done with each other. Your daughter, who is the lessee, signed this agreeing for the 2 months' rent and to forfeit the $925 deposit. And there's an acknowledgement that the horses did damage to the property. That's it. So you have no case.
Does it say acknowledgement?
What?
Does it say that, acknowledgement, or if there was damage to the property?
No, it says we have agreed that the deposit is forfeit to cover some of the damage done by the horses. Now, you're really being so annoying to me. I'm just about.
I'm preparing my next piece of paper. That's all.
Just a second. Don't prepare anything. So far, you're not losing. The only thing you're losing is my patience.
Gabrielle and Angela Alfredson claim their stable landlord, Glenn Garatiano, is wrongfully keeping their rental fees and deposit. Glenn is countersuing for property damage caused by their horses.
Okay. We have agreed that the deposit is forfeit to cover some of the damage done by the horses. Now, if I were you, one word I would have absolutely eliminated is some of the damage, because that says to you, bing! It's not to liquidate the damages done by the horses. It says to cover some of the damage done by the horses, which is his counterclaim. So the fact that this didn't work out and you were unhappy is absolutely irrelevant to a lawsuit. Do you understand? Irrelevant. Now, did you and your tenant have any discussion about what damage you allege that the horses did?
Yes.
Was that the day that she left?
No, ma'am. It was prior to that, numerous occasions. Can you imagine I have something important? Just please, sir, ma'am. I have something important to show you.
Sure. Give it to Kevin and answer my question.
I shall.
Great. Do you have anything in writing, emails, etc., to demonstrate to me, other than verbal conversations, that the tenant was made aware of damages that the horses would...
The 43 pieces of evidence I
would like, just a second,
does have that evidence that you're asking for.
Everything that you're going to hand me in that 43 pages, I just want to let you know, because when I go through 43 pages, if all of it is not relevant to the damage and the amount of damage that the horses did, that's not going to put me in a good mood. So make sure you're sending me all that stuff. Hold on a second.
This is important prior to even looking at that receipt. If you'd please refer to the last page of the summons and complaint.
What are you showing me?
What I'm showing you, ma'am, is that the summons and complaint was filed by the father.
I don't care.
No, ma'am. This is filing an illegal court document. I don't know why you don't care.
I don't care because I wish I could care. For your sake, I want to care. But for the purposes of this case, I don't care. All I want to see from you is the damage that you are alleging that was done to your property in excess of $925, which you kept as security deposit. That's all I want to see. I don't want you to tell me that her underwear doesn't match, that the wrong person filed the summons and complaint. I'm not interested. Very simple. Do you understand? Do you understand what I said to the plaintiff, sir? Did you understand that? Don't hand me all that stuff.
I'm not. I'm saying it's in folder 4 right in front of you. Those are the damages. The damage to the grass in front of all of the
No, that's not what I asked you for. If you follow instructions, I said to you, I want to see in writing, which you said you had, notification to your tenant prior to March 13th that damage was being caused to the property. And you said numerous. I said, show me. You said, I have 43 pages. I said, I'm not reading 43 pages unless it's all relevant. And if I read 43 pages and if it's not all relevant, it's going to put me in a bad mood, which I'm getting to.
Quickly, I see that.
Yes, because this is a lawsuit. It's not a kvetching contest.
It's not about fetching.
Do you understand? I didn't let her kvetch. I said, this is a lawsuit. You want your money back? You signed the document that says you're not getting your money back. That's what you signed.
The damage estimates are in the back of that folder.
And I told you, I'm not asking you for estimates.
Okay. You're asking me for communication between me and them? It was mostly verbal.
So then the answer is you don't have anything in writing.
There may be text messages. I didn't review them.
Oh, okay.
But
so
there were text messages regarding
yeah,
her trough that was leaking, and she just ignored the text. She ignored text often.
I actually don't care.
I have pictures of the damage to the stables in there.
Yeah, $925. You got it. It's covered. You counterclaims dismissed. We're done. This case is over.
This court is adjourned.
The man was very harassing to me the whole time. I didn't get to show any of my text messages.
She was a week late with the rent. She signed the lease, brought the horses, and then, oh, I forgot the rent.
Into the second week we were there, I told my daughter, something's wrong with this man. We got to get the horses out.
A week later, she comes back with the rent. I'm like, where's the deposit? She goes, oh, I didn't have the deposit. I'll get you that in a week.
He wanted me off the property. He said, I want no trespassing ordinance on you. I said, can I not feed my horses? No, get off the property.
These people were bananas, and they were damaging horses.
Good example out there of we here in court hear legal arguments, not emotional arguments. It can be, a therapeutic experience for the litigants to be able to get their story across or share the underpinnings of the story or what really went on is something that we hear a lot in court. But it doesn't matter how many color-coded files you have if they don't contain evidence that are pertinent to the legal argument, not the emotional argument. We don't want to see them. We don't want them.
Especially in this case.
It was cut and dry.
In this case, there were contracts.
Yeah, signed.
There were two
no
contracts,
argument.
a lease and a termination of that lease with the terms.
Yep.
And there was only one word, Sarah, and that word was some.
And that allowed him to even bring the countersuit in the first place.
But it was sort of slick, the word some. If you're going to forfeit your $925 deposit, and what he's primarily complaining about was that the horses ate all his grass in his meadow. Right, for $925, you can buy an awful lot of grass seed.
Sure.
They're not about to build him a whole new piece of property. Didn't work out. There was a contract. Sort of interesting. Yeah.
Case number 3035, Zackerson versus Farber. All parties, please come forward.
Sarah Bell Zackerson is suing dog groomer Tracy Farber for negligence after losing her dog, Benji.
Miss Zackerson, you're a dog lover.
Yes.
And for years you had 5 dogs or 4?
5.
What kind did you have?
I have a Maltese poodle, I have a cabin poodle, I have a poodle, Shih Tzu, and some dog I found in the street. I don't know what kind it is, but yeah.
Small dogs?
Yes, small. They don't weigh more than 15 pounds.
And for a very long time, Miss Farber has groomed your dogs.
That's correct, just under.
How many years has she groomed your dog?
I can't exact the time, but it's going to be almost 10 years.
And you usually bring the dogs to her how often?
I never bring my dog to her house, always to their shop. She used to have a business shop they call TLC Grooming, and that's where I bring my dogs over.
When did that change?
December the 1st, I texted her and say, I'm going to bring my dogs tomorrow, 6 of my babies, to the shop. And then she said, oh, I was about to text you. I'm going to close the shop for good. And I said, oh, wow, what happened? She said, well, I had to take care of my husband. He's kind of sick with her heart failure stuff. So I don't want to be away from him. So you can bring them to my house and I can groom them. So, and I said, well, I want to send my brother over
So
there.
you were sending 6 dogs?
6. That day I sent 6.
And you decided to have your brother bring them to the house?
That's correct.
And that was on December 2nd?
That was December the 2nd.
Okay, and how long did the dogs usually stay there? For the day?
Say to end of the day, because they're 5.
So 1 full day?
Yeah.
How much do you pay her for the 6 dogs?
Depend what you do, because some of them go every week, some of them once a month, some of them twice a month.
How much did she charge for each dog?
If you go once a month, 50. If you go twice, 25. Depends.
So there's less work if you maintain the grooming?
That's correct.
Got it. So on December 2nd, who brought the dogs to her house?
My brother.
Is that this
That's
man
correct.
here? Okay. Could you step up, please, and tell me your name?
My name is Bishop Bean, and I'm my sister's brother.
You brought the 6 dogs to the defendant's home?
Yes, ma'am.
Tell me how you brought them into her house.
I brought them up to her and just gave it to her by the sliding door.
How?
Just one by one.
So you handed them to her individually, unleashed?
Yeah, by holding them on her.
And you just handed them to her?
Yeah.
Okay. Where did you pull up in the car?
In the driveway.
You brought them into the door, or she came out?
I brought it to her.
Okay. Did you also pick the dogs up?
I picked 4 of them, but one was missing.
So only 5 were sent that day. When you went to pick up the dogs, you only saw 4, or did you see 1 and 1 ran away?
When I went to pick up the dog, I only realized that there were 4 and 1 was missing, and when I went to ask.
Where did you go? Did you go inside her house?
I didn't go inside the house.
Well,
I picked it up on the side of the driveway.
How?
They opened the door of the driveway. It's a big sliding door that they have that can open just a little bit, so they can hand me the dog.
She handed you the dogs?
Not her, but the son.
Is that you?
Yes, ma'am.
Okay, stand up next to your mother. Okay, tell me your name.
Nicholas?
Nicholas, when the plaintiff's brother came to pick up the dogs,
Yes, ma'am.
how many dogs did you give him?
I gave him 4 and asked my coworker to bring out the other one.
You help your mother with grooming?
Not with grooming, but in the mornings I go to a park, pick up dogs that we had scheduled, and then bring them back. Later in the evening, I take them back to the park.
Okay, so you asked a coworker to go get the 5th dog, which was where? In a cage?
That's what we believed, yes.
What do you mean that's what you believe? You say that you were forced to drain the pool because they thought that maybe the dog fell into the pool. I don't care. I don't care if you have to drain your whole house.
Sarah Bell Zachrinson claims dog groomer Tracy Farver lost her dog Benji while in her care. Tracy is countersuing for the cost of draining her pool.
Okay, so you only turned over 4 dogs
Yes, ma'am.
to the plaintiff,
Yes, ma'am.
plaintiff's brother, and you don't know what happened to the 5th dog,
No, ma'am.
personally,
Personally, no.
and you never saw the 5th dog on the 2nd.
No, ma'am.
Okay. Do you know what happened to the 5th dog?
Yes, ma'am. The 5th dog was released to him. He had dogs in the vehicle and came back to ask me.
Just a second. Were you there?
Well, I was in the salon after the dogs had already been given to him.
Your son only gave him 4 dogs.
But he was not the only one involved in giving the dogs back.
Then you should have brought that person because you weren't there. You should have brought that person because you weren't there.
Should have.
Well, your son says he only turned over 4 dogs. He asked his colleague to bring out the other one. The other one wasn't there. Am I getting that right, sir?
Yes, ma'am.
Okay. Well, so just don't talk to him. He's talking to me. You can have a seat now. Okay. So, Ms. Farver, bottom line is, you can sit down now.
Thank you, ma'am.
The plaintiff's brother, at her direction, brought you 5 dogs. Only 4 were returned to her, so 1 was missing in action on your watch. 1 dog. That's clear. Now, she's suing for the negligence. She doesn't know what happened to that dog. You have a counterclaim that's sort of ridiculous.
Well, I have proof that she says that she lost her dog there.
Just a second.
He misunderstood.
Just a second.
And when he counted, he said that Benji ran out with them. But he said that Benji runs away all the time.
Just let me explain something. Let me explain something to you. Your witness that you brought with you today said he only turned over 4 dogs to the plaintiff's agent.
But he wasn't the only one that turned over dogs, and then he leaves that situation to go deal with another situation.
Deal with me, and I've said to you, then you didn't bring the second witness because you weren't there. You didn't bring the second witness to say, I did in fact turn over the dog to him. Did she? Just a second. Did you on December 2nd ever see that dog?
No, ma'am.
No. Okay, that's what I thought. All right, so you're responsible for that dog. Now, the dog was how old?
14 years old.
And what was the breed of that dog?
Maltese Poodle.
When you found out that that dog was missing, I gather you all went back and tried to find it.
Yes.
Yes, Your Honor.
That you all went back to try to find it, and you couldn't locate on your property. How much property do you have, by the way? How many acres property do you have?
It's about an acre and a half. Do you want to see pictures? It's all...
No, I don't have to see pictures. The dog was missing. That's your problem. That's your problem. The dog was missing under your watch. So there's a question of damages because she's entitled to a certain amount of damage for the loss of her dog. Unfortunately, we talk about replacement value. You know, how much is a multi-poo to replace? I don't know. Could you look up, Sarah?
Sure.
The cost. Give me a general price of the cost of a multi-poo. They're cute.
Just on an initial search, so it looks like $2,000 to $3,000 when purchased from a breeder, but can go up to $4,000 for certain colors and reputation.
Okay. So we talk about replacement value. Replacement value is about $2,000. The dog was 14 years old. I'm not even factoring this in. You had that dog for 14 years?
Yes.
Okay. You're entitled to that. This is what your counterclaim is. Your counterclaim is ridiculous, and I'm dismissing it. You say that you were forced to drain the pool because they thought that maybe the dog fell into the pool, and it cost you $2,800 to drain the pool. I don't care. I don't care if you have to drain your whole house. Your counterclaim's dismissed. Judgment for the plaintiff in the amount of $2,000. We're finished. Thank you very much.
This court is adjourned.
Well, I mean, I'm happy for Sarah Bell. You know that she feels like her grief was compensated.
When she lost my dog, she never told me.
You know, he was a known runaway and didn't have any identification and wasn't chipped.
You lose my dog. It's belonged like my son, you know, my kid. For 14 years old, it's meant a lot to me.
I wish that we would I've always wished we'd find him.
I miss Benji a lot.
So I have a little issue with the concept, legally overarching, of the replacement value of things, dogs, even loved ones sometimes in wrongful death suits, because it doesn't get to the heart of what you actually lost. So yes, on a brief Google search, I could find a multi-poo puppy for, say, $2,500, but does that really make up for the 14 years that the plaintiff had with her original dog that the defendant lost in her care? I felt inclined, like I wanted to give her more for that pain and suffering of loss, but that's not what the law gives us as a remedy.
First, she didn't sue for that, but as a dog lover, I can tell you how excruciatingly painful it would be for me to bring Joey to a groomer and come back and they say, I'm sorry, we don't have her. I remember taking a dog many years ago to a groomer, and when I brought her back, she had a cut underneath on her belly. I wanted to go and commit a murder because the groomer hadn't told me about it, but for the fact that I saw drops of blood on my carpet, I wouldn't have seen it. So, you know, it was a dog lover, and clearly this plaintiff was a dog lover because she methodically had them all groomed.
She was talking about twice a month on occasion.
Twice a month, sometimes once a week. She clearly loved her animals and was careful with them. If she had this dog for 14 years, that's a pretty full lifespan for a dog. But very traumatic. You bring 5 babies in and you only get 4 back. I'm sure it wasn't purposeful on the defendant's part because she had been a great groomer and the